Future Millionaire. I thank you all. The incredible show of support is absolutely overwhelming. Yesterday we had 848 followers. Today we have 1,047 just 12 hours later. I'm blown away. So this is from April 29, 2022 from Honorable Judge Sarah Netburn, page 2 of 6. The overwhelming demand for the HINMan files, the official documents I've seen, so I'm going to continue releasing as you want them. On June 4th, Director HINMan circulated a draft of the speech to officials outside the division, including the Deputy Chief of Staff for the SEC's then Chair, the SEC's General Counsel, and the directors of other SEC divisions and offices, requesting comment. So in the ensuing days, attorneys from the SEC division and offices, including attorneys in the Davison of Trading and Markets, Division of Investment Management, and the Office of the General Counsel, provided legal analysis of the draft. On June 12th, attorneys from TM, IM, and OGC provided a second set of substantive comments on the draft. So let's read farther down. So SEC can redact comments and edits containing and reflecting legal advice without withholding the entire document. Finally, the SEC is withholding portions of the transmittal emails that contains legal advice, entries 5, 32, 33, 34, 49, 51, 52, 58, and 63. This is the important part. Speech drafts and transmittal emails contain communications protected by the attorney-client privilege. The attorney-client privilege protects from discovery those confidential communications between client and counsel made for the purposes of obtaining or providing legal assistance. The government's claim to the protection of the attorney-client privilege is on par with the claim of an individual or corporate entity. Citizens Union of City, New York, our Attorney General of New York, 269F, and you guys can read that. The privilege functions to encourage attorneys and their clients to communicate fully and frankly, and therefore promotes broader public interest in the observations of law and administration of justice. The application of the attorney-client privilege in the government context furthers a culture in which consultation with government lawyers is accepted as a normal, desirable, and even indispensable part of conducting public business and grand jury investigation. So therefore, if anything, the traditional rationale for the attorney-client privilege applies with special force in the government context. To invoke the attorney-client privilege, a party must show, 1, a communication between client and counsel that 2, was intended to be and was in fact kept confidential, and 3, was made for the purpose of obtaining or providing legal advice. The drafts and emails that the SEC seeks to withhold under the attorney-client privilege reflect communications between SEC officials and SEC legal counsel made confidentially to obtain legal advice, because Director HINMan, as an SEC official, is communicating with SEC attorneys as would any private party seeking advice, Coastal States Gas Corp. So that was from 1980. These communications fit squarely within the protection of the attorney-client privilege. Very, very interesting indeed. If you want to see more, subscribe and let me know in the comments for page 3.